O'Connor is here. Judge Armada. Judge Green.
Present.
Judge Maturowski.
Present.
Judge McLaughlin. I believe she's on trial. Judge Pearson.
Present.
Judge Prats.
Present.
Judge Stewart.
Okay, we do have a quorum.
Yes.
The first item that I'll take up is the approval of the minutes from the October 30th, 2023 meeting. Is there a motion to approve? And Judge Stewart has, okay, Judge Armada has moved it. Judge Stewart has now joined as well. Is there a second to approve the minutes?
Second.
It's been moved and seconded. Are there any additions or changes to the minutes? If not, all in favor, just please raise your hand. That passes unanimously. The next item is 2023-006, a proposal to create hybrid files upon request in cases filed on or before 2014, in which the older part would remain in paper and new entries would be digital. This was a proposal that had been sent to the Rules Committee. Attorney Del Campo can tell me if I get this wrong, but Attorney Zelotes had recommended this proposal along with another item, and we had asked Judge Bellis to weigh in on it. She worked with Judge Albus and Judge Diana on it, and all three of them are recommending that we take no action on this item at this time. Is that correct, Attorney Del Campo?
Yes, Your Honor, with the addition of they brought it, Judge Bellis, Judge Albus, and then Judge Diana brought it to the Judges Advisory Committee on e-filing to have them consider it before they distributed it further. And that committee, again, suggested that it could not dedicate the resources and should not dedicate the resources to doing this.
Thank you. Is there any contrary view from members of the committee? If not, is there a motion to table? Sorry, Judge Stewart.
I don't know that this quite weighs in as a contrary view, and I don't sit family anymore, but I do have to say it was very aggravating for the clerks and for me to not have the more, I understand not, taking I had files from as far back as 1994. I understand not taking those and, scanning them all in, but it was aggravating for the clerks on the receiving end for filing them. I don't know whether there's a way to find out. I agree with the notion of tabling it, but I'm wondering if there's a way to reach out to the clerks or somebody on their behalf to find out what they think about it, because an enormous amount of energy was consumed receiving these things from the fax machines, filing them, and then trying to scrounge up stuff for us.
I have no problem passing this for a month, and we could get the input from court operations if I think that would be the appropriate avenue to solicit input from the clerk's offices. Does anybody disagree with that? So if that's, I have absolutely no problem doing that. So why don't we pass this until our next meeting, and I'll ask Attorney Del Campo to also refer this item to the court ops for its input, and specifically asking for input from maybe the various chief clerks of each of the JDs. And just to take a poll, not to have everybody comment individually to us, but to synthesize the comments from the chief clerks. Does that sound okay? All right, we'll handle it that way then. The next item is 2023-007. It's a proposal to grant active members of the bar online access to family cases via e-services in cases in which they do not have an appearance. And this was also a recommendation from Attorney Zelotes. And I understand the problem, obviously, but we also solicited the input again of Judge Bellis, Judge Diana, and Judge Albus and the Judges Advisory Committee, and they too said that this had been something that had originally been looked at. I'm sorry, I'm mixing up the prior item. Attorney Del Campo saved me from myself.
No, you're correct, actually. They went also to the Judges Advisory Committee and they indicated that it had been talked about originally at that committee years ago and decided that it would be as it is, that attorneys could go to any courthouse to see whatever's in the court file. It doesn't have to be the particular courthouse where the case had been filed or tried. And again, they decided that they did not want to do this, and Judges Bellis, Albus, and Diana agree with that and are not in favor of this.
Did anybody, any members of the committee wish to comment on this item? If not, is there a motion to table this item?
So moved, Judge Pearson.
Is there a second?
I'll second it, Judge Armada.
Any discussion? If not, all in favor, please raise your hand. Opposed? That passes unanimously. The next item on our agenda is a proposal for 2023-011, proposal for requirement that attorneys who use AI programs to conduct legal research append a certification to their pleadings that they have independently verified the accuracy of the citations. This also was a recommendation from Attorney Zalotis. Ironically, it jives very nicely with what we've talked about at our last two meetings about artificial intelligence. And I did send around something to members of the committee on this subject last week. We had decided at that time not to take any action at this time. I will just reiterate, I am very, very nervous about what I don't know about artificial intelligence and how it could be used. I had originally talked about something like maybe as simple as doing a certification at this juncture, but I think the consensus from other members of the committee was that we should take a wait and see attitude at this time. And unless anything has changed, I assume that's how the committee would still wish to proceed, but I'll open it to discussion. Judge Armada.
So one of the things that I think groups are having a hard time is defining what is artificial intelligence, because Google's artificial intelligence, Grammarly's artificial intelligence, even things like spell check and some of our Microsoft, it anticipates what we're going to do and then do it. So sort of defining what it is that we're trying to get certification on, where there's not even a consensus of what that is. And it is developing exponentially. That's the problem that I got communicated to me from, I think it was Jonathan and Shapiro and Dina Castricone, is it's evolving so fast, trying to define it is hard. So I just put that out there for consideration.
And Judge Pearson, and then Judge Prats.
Oh,
And then-
thanks. And it is developing quickly, and my sense is when you read a law review article about it, by the time the article comes out, it's already old news and no longer, at least in part, no longer relevant. But the comment that I was going to make was that while this may be a good idea, I would not want to approach this problem piecemeal, with one rule here and one rule there. I think it's not that we necessarily have to solve all the problems or address all the issues that may arise, but I'd rather not do this piecemeal. And I think maybe some more time to reflect on what other rules changes might be appropriate in addition to a change in the certification rule. We need some more time to think about a holistic approach to this problem.
I appreciate that. Unfortunately, as soon as we come to some idea of what we think should happen, it will have already evolved past where our thinking is. But
That may be.
Judge Prats was next, and then Judge Chaplin.
Yes, thank you. I never knew about this artificial intelligence and how the sites come up that are extremely like they're fake. That's a true concern to me. I don't know how we could incorporate. I think it's a good place to start, if even if it's with citations or something, because this is really disturbing to me that it will come up like this. So I don't know. I mean, just I don't know. Like, I don't think that's a bad thing to have something to state if you used something, and I don't know how we would, you know, I guess define it, but that you have checked the citations at a minimum, and not rely on whatever the source is, just to that they're true. You know, I think that it's a good place to start. Let's put it that way. Something along these lines.
Thank you. Judge Chaplin, then Judge Green.
Thank you. I want to primarily echo the comments of Judge Pearson regarding just the piecemeal approach. It could lead to some other concerns and unanticipated results after the fact if we choose a piecemeal approach without being considerate of what the entire scope of this issue really becomes. Another thing I would say is the limited nature of this request is only as to citations, I think misses the mark by a big degree as well, because the idea of using ChatGPT for citations misses the point where ChatGPT is used to write briefs now. So it doesn't address that concern. And just, again, I think I mentioned this in the last meeting, my intercourse group, we just did a presentation last week or week before about this very issue. And I have learned a great amount, way more than I thought I would or wished to know about ChatGPT and its utilization and how much it can be done, how frequently it could be used without us even knowing currently. But I do think that a more comprehensive approach would better serve all involved rather than piecemeal approach.
Thank you, Judge Green.
I was going to say that we agreed last time to basically not really talk about it until next September. So, I mean, it seems to me that we should, if I agree that it should be a holistic approach, but I mean, maybe we should reconsider putting it off until next term. I understand some of AI and some of those things that people are concerned about. My concern is that if AI or ChatGPT is generating briefs that are not based on just miscites, but on fiction, then that whole brief would not be reliable. So, and that's unlike any of the other sort of services that have been used. I mean, we are comfortable with Westlaw. We are comfortable with LexisNexis. I mean, all those things, to the point we're not using print cases anymore. We have all these case books in our offices, all these, and you don't even have to go to them because we trust Westlaw. But if something's generated by ChatGPT, it may not be trustable at all. So I'm just saying that maybe we should address it before next September, or start addressing it.
Let me just jump in on that. Actually, by happenstance, I got a advertising postcard for a national conference being put on by the National Civil Justice Institute on artificial intelligence in the courts for July in Nashville. And for reasons that are not clear to me, it's open to appellate and Supreme Court judges only. But I'll take this offline with Attorney Del Campo. I'm going to try to see if somebody, maybe from the Chief Court Administrator's office, because it's an issue of concern for not just appellate courts, but all courts, whether we could get somebody from the judicial branch to maybe attend that conference, because it is going to be a national conversation among judges, which I think would be helpful. But Judge Stewart.
A couple of things. First of all, I'm definitely in the wait and see camp. I've gone to 2 conferences on AI, including one recently put on by the Connecticut Bar Foundation that had a couple of, well, all the faculty at the program talk nationally on this issue. And a couple of them addressed what various court systems are doing, or in the case of the federal court system, intentionally doing nothing so far, taking a wait and see attitude. But one thing about this particular issue, and the other thing I'll comment on is my understanding is CJI is going to have as one of its plenary sessions in June, AI. Not exactly sure what what part of AI they're going to be talking about, but there is going to be an outside speaker, or actually more than one, I believe, on that topic. But the other thing I'll just comment on, I was frantically flipping around because it's been a while since I had to file an appellate brief, but I believe our appellate and Supreme Court here require the brief writers to certify certain things, whereas those of us who are just in the trial courts, you just file a certificate of service, pledging that you mailed or now emailed whatever it is you filed to the other side. If we were to adopt something, because I agree with the comments, it's not just the sites, it's the entire content. If we were to adopt something, I think we should have a general certification that would apply not just in the appellate courts, but also to the Superior Court for the entire content of the filings, but something to think about for the future.
Any other discussion? Okay, why don't we pass Judge Rossiger? Sorry.
Matuszewski.
I always have struggled with your last name pronouncing it. I apologize.
No, that's no worries. I always have to, it's like lighting a match. Matuszewski. I think I'm also in the wait and see, but I guess the question is there an active versus passive waiting and see? In other words, does it make sense to be monitoring this in some way? Obviously, there is a lot going on in terms of what other courts are doing, some of the seminars that are taking place nationally, that kind of thing, rather than just wait and see and then come back in September and we haven't really thought about it.
So I had informally offline asked Judge Armada to try to be a point person, if you will, for the committee to look at emerging issues and talk to stakeholders about this. Obviously, if anybody has any input, please share it with Judge Armada. I have also actually asked Judge Bizzuto and Judge Facito to make sure that trial judges are keeping their eyes out for any abuses or misuses of AI and to funnel that information up to the Chief Court Administrator's office as well. So I don't think it is passive at all. It's actively monitoring what's going on to hopefully get our arms wrapped around this a little bit more. Judge Armada.
Yeah, I just want to point out that two big stakeholders, the American Bar Association and the Connecticut Bar Association, are acutely aware of this phenomena and how fast it's developing. And they've created specialized subcommittee that are working, but they're just coming together now to say, we've got to look at whether the genie's out of the bottle and what does this entail. And it's not just writing briefs. There's programs that tell you closing arguments that help you with presenting of evidence. And the question is whether the evidence is true, those type of things. So they're aware of it. And I think we've got to see where they go in terms of recommendations. And again, they keep stressing the product is changing and defining artificial intelligence, and what that is a moving field.
And, just perhaps to state the obvious, attorneys not only have responsibilities for their certifications to the court, but there are ethical considerations as well to clients. And I guess word just needs to go forth that attorneys use this technology at this time at their own peril if it's misused. Other courts, and I think judges have the inherent authority to sanction attorneys in appropriate circumstances as well. So I don't think it's going to be a passive period, but I do think we need to look at this a little bit more closely. I have actually talked to Justice Doria about potentially changing some of the rules of appellate practice as well. I think they are looking for some guidance from this committee first. So why don't we pass this at the moment? Attorney Del Campo, maybe you can merge this item with the prior item that we had discussed, so we don't have two different tracks going here. But I do want to, I know Attorney Zelotes is on the meeting, and I just want to thank him for bringing this to the committee's attention. It's not lost on us the importance of it, and we had been already thinking about it. So thank you very much.
Well, thank you, Your Honor.
Okay, we'll pass that then until September, and Attorney Del Campo, maybe you and I can talk about finding whether we can get somebody to Nashville in July. Next is 2023-016. It's a proposal to amend the practice book to require all attorneys and self-represented parties subject to e-filing requirements to accept service of documents electronically. Attorney Del Campo, is there anything more than the letter we've received?
No, there is not, Your Honor. This is first time being considered, so it has not been referred to any entity or person at this point.
So obviously, I'd want the input of the various CAJs, and I'm sorry, Attorney Zalotis, did you have anything you still wanted to address to the committee?
Sure. Well, good afternoon, everyone. I just wanted to share just preliminary thoughts, being that this is the first time that it's come before the committee. Obviously this, from my perspective, maybe speaks more to the practical lawyering side. This proposed amendment doesn't really have probably a significant impact on the court operations itself, but I'll share some of my thoughts of why I'm suggesting that the court incorporate this. So first of all, 90%.
I'm sorry, are you talking about the e-filing item that we're talking about now?
Yes.
Okay.
So
go ahead.
So the suggestion that all attorneys, right now you have to opt in order to, I agree to accept electronic delivery of papers. Otherwise, if you don't check that box, the rules say that you have to serve everything by the U.S. Postal Service. Now, I would say that probably 95% of the attorneys have joined us in the 21st century who are emailing, but there is still this 5%, maybe 10% out there who are not checking this box. And crazily enough, a lot of the people who aren't checking this box are young attorneys. They're in their 30s or early 40s, and they're very familiar with the technology. And I'm saying to myself, why are our attorneys, well, first of all, one of the concerns is gamesmanship and gotcha. So if they're exchanging documents regularly via email, you show up in court and then they say objection. Well, what's the objection, counsel? Well, we didn't check the box that said we accept service by papers. They sent it to us by email, and therefore we feel that the notice isn't proper and that we shouldn't go forward in that motion. I've seen that gamesmanship played before. I don't think it has any reason or excuse to exist in this day and age. So I think that's one of the things that I wanted to address, to avoid that kind of gotcha gamesmanship by checking that box. The other thing is, why are attorneys spending 50 cents to save another attorney 3 cents in toner, and then having the secretary or the assistant then package it out, send it out, bill the time for the administrative costs, just because the attorney on the receiving end would just like somebody else to hit the printer and use their paper? It's just wasteful. This cost ultimately ends up getting passed on to the clients. And unlike, the U.S. Postal Service, with a email, you've got proof that it was sent, when it was sent, who it was sent to, as opposed to, well, we never received it, or we only received it today because you sent it out and then it took a couple days for it to get out there. So in any event, that's just my general thoughts from a lawyering perspective in terms of what my thinking was. I think, if everybody's on board with e-filing, if everybody, can do Zoom conferences and team conferences, because that's part of what we've been doing post-COVID, I think certainly we can all, get on board with accepting service by email. So I'd like that last 5 to 10% to sort of join the rest of us here in the 21st century. So that's all I have to share.
Thank you very much. I obviously would recommend that we get the input from the CAJs of all of the various divisions, but are there any other recommended stakeholders that we solicit input from? Attorney Del Campo, can you think of anybody?
Just court operations, Your Honor, if you'd like to send it there.
Sure. Judge Armada.
How about the Connecticut Bar Association, specifically the family law section?
I would recommend we just send it to the Bar Association and let them distribute it to their various sections as they deem appropriate. I see Attorney Latarullo, who proposed this is asking for some time, and we normally have a comment period later, but for efficiency sake, why don't you engage your camera now and be happy to have your comments.
Can you see me and hear me?
I can.
Well, I want to thank Attorney Zolotis for his very eloquent support of my request. One of the things in my line of work, I do a lot of summary process work. And for some reason, the clerks will time various decisions based on the manner of service. So I have a number of attorneys that typically who file appearances in my cases will not check the box to receive papers electronically. And the clerks, since documents are being mailed, have to afford more time before they rule on things like a motion for default for failure to appear or a motion for default for failure to plead. So it does affect kind of the substance of how cases are handled, and it causes some delay in the summary process. So with all of the previous comments made by Attorney Zolotis, I want to add that in summary process, there's a greater number of parties that do not participate in the acceptance of electronic filing. I mean, in a perfect world, I wish we had something akin to the federal system where any party that's appeared would immediately get a notification of a filing, and you get an email notification, you download the link, and there's the document that's been filed. We don't have anything like that. We still actually have to make service. And as Attorney Zolotis indicated earlier, we do have that proof now that it was emailed on a certain day at a certain time. But in the summary process realm, I can tell you that there are a number of lawyers, and I will agree with him that it's some of the younger folks who do not accept electronic filing, I think specifically to slow things down in these types of cases.
Thank you very much.
Thank you for the opportunity.
Okay. All right. Well, why don't we? When's our next meeting, Attorney Del Campo?
December 18th, Your Honor.
I don't know if that's going to be enough time to get the input from all of these folks. Why don't we ask that it be received by the committee in late January, so it's available, in late December, so it's available to us for our January meeting. Okay. Does that sound like a fair disposition at the moment? Okay. Thank you very much. Then the next item on our agenda is 2023-017, proposal to amend practice book section 25-5B1 concerning automatic orders upon service of a complaint or application and clarity with respect to premarital or postnuptial agreements. Attorney Del Campo?
This also, Your Honor, as it was the last one, is first time being considered, so it is what the proposal is all you have at this point. So you may wish to refer it out.
Does anybody see that we should get input from anybody other than Judge Diana? Okay, so Judge Armada.
I'd again refer to the CBA for comment.
And I appreciate you catching me when I fall. I also agree that that should be sent to the CBA family section. Anybody else have any comments? If not, let's keep that on the same time frame so that we can consider this at the January meeting. The next item on our agenda then is 2023-18, a proposal for supervision of civil jury selection in every case to curb abuse and delay currently occurring during voir dire in Connecticut. It's not my view, it's just what the agenda said. This was a proposal from Attorney Healy, and I believe Attorney Healy was on the call. I would give him 3 minutes if he'd like to address the committee on this item. Attorney Healy, are you available?
I am. I don't know. I don't see that my camera is disabled, but I will try again here. I thought I had authorized that, but in any event, good afternoon, folks. I am a member of the Connecticut Bar since December of 1989 and have probably picked many juries in my time on the civil side and have been disappointed during that process and since to not see judicial supervision of that process. And I absolutely think it's necessary. And that would be my request as both a citizen of this state and as a practicing attorney of many years who picked jurors. And I see in the task force report that was done in 2000 that at page 33, there was consideration by the peremptory challenge subcommittee. And I think not enough attention was paid to the issue. And I would ask you folks to consider reconvening some type of reassessment of that. There was mention in the report that there was no empirical study or data to support that there was any prejudice or bias occurring that would make judicial supervision appropriate. And I would ask that that be revisited, perhaps on some basis for some of the judges who might be available to say, I'm just going to sit in on this day of voir dire and see what I think. Is it taking too long? Are the questions inappropriate? Are the attorneys jockeying for position to taint the process? Those kinds of things. And if a judge were available to sit in for an hour or two or a day on a voir dire that's taking 5, 6, 7, 8 days on a civil jury case, I think that would be good for the people of our state.
Thank you very much, Attorney Healy. I appreciate that. And if you could mute yourself and turn off your camera, I'd appreciate that as well.
Yeah, sure.
Okay, I suspect I will, I know what I will hear when we ask for input of this. It's, in theory, might be a good idea. As a practical matter, I really doubt whether the branch has the capacity to provide that type of oversight in civil jury trials. But it has always been our practice to refer these items out for comments from stakeholders. So I would ask that we send this out to, I was just going to say Judge Abrams, who's I can't remember the CAJ of civil right now.
Judge Bellis.
Right, Judge Bellis, to Judge Bellis and to court operations, and of course to the CBA before Judge Armada has to remind me of that, and ask that that be set on the same time frame. I do want to note, I anticipate the proposal will not meet with great welcoming remarks from stakeholders, not because it wouldn't potentially be a good idea, but because it would be an impractical one, given the amount of time. It doesn't mean that, and I should just say, because I know Attorney Healy's still listening, it doesn't mean that you can't ask for judicial intervention in voir dires and civil cases on a per case basis, but I doubt that a rule will be forthcoming that all cases would have to be supervised by a judge. Does anybody disagree with having Judge Bellis and court operations provide their input? If not, we'll proceed that way again on the same time frame, Attorney Del Campo. And I don't believe we have any other business before us. Is that correct, Attorney Del Campo?
That is correct, Your Honor.
Then I will accept a motion to adjourn.
So moved, Judge Pearson.
Is there a second?
Judge Chapman, second.
It's been moved and seconded. All in favor, please raise your hand. Opposed? That passes unanimously. I appreciate everybody's time and attention. We stand adjourned.
Take care, everyone.
Thank you.
Thanks, everybody.